Thank you all for joining. We're just going to give it about 30 more seconds to let everyone in, and then we'll get started.
Should we sing for these 30 seconds or play hold music or anything like that? No.
If you'd like to, yes, go for it.
And people didn't sign up for that. We won't subject them to that just now.
All right, I think that's 30 seconds, so we'll go ahead and jump in. Good afternoon, everyone. Welcome to today's webinar brought to you by the American Immigration Council. We're grateful that so many of you are able to join us today. My name is Michelle Lapointe, and I am the legal director at the Council. I will be your moderator for today's webinar on the Supreme Court. I'm joined today by Ahilan Arulanantham from the UCLA School of Law. He's the faculty co-director for the Center for Immigration Law and Policy. Also, Karen Tumlin, founder and director of the Justice Action Center, and Kate Melloy Goettel, clinical law professor at the University of Iowa College of Law. For those of you unfamiliar with the Council, we're a nonprofit organization that believes that the U.S. immigration system should be fair, just, and welcoming. We pursue this objective through a multi-pronged approach, including impact litigation, advocacy, research, transparency efforts, narrative change, and expanding access to counsel for immigrants. A couple of housekeeping matters. We will be sending out a recording of this webinar, and we will do our best to save time for a Q&A at the end, but you can also put questions in the chat as we go along, and panelists will do our best to answer them. So let's jump right in. One theme from this term at the Supreme Court is that while there were 3 pure immigration law cases, there were several non-immigration cases that will likely prove extremely consequential to litigation in the immigrants' rights arena. We'll discuss those in turn, but we're going to start with the immigration-related cases that the court considered on its so-called shadow docket. We've heard a lot about the court's shadow docket, where it decides cases of national importance, not on the merits, but on essentially emergency requests to the court to issue temporary, seemingly procedural rulings that have substantive impact. Through the shadow docket, the court also has a policing role of what the circuit courts and the district courts are doing, but this is a role that the Supreme Court does not always apply consistently. This term, there were 2 shadow docket cases relating to immigration issues. Both of them dealt with struggles between the state of Texas and the federal government over immigration authority. So we'll talk about those now, and I will pass it to Ahilan.
Thanks very much, Michelle, and thanks to the Council for having me. It's always a pleasure to do this event. I'm glad we're starting with these 2 cases, US v. Texas and Las Americas Immigrant Advocacy Center v. McCraw, which were 2 cases challenging Texas SB 4. It's a truly extraordinary law. It really seeks to remake the constitutional order on immigration in a fundamental way. I actually think in a lot of ways, it's kind of like June Medical, the case which effectively upheld Texas's abortion ban before the Supreme Court actually upheld the abortion ban in Dobbs. It's not, however, currently in effect. SB 4 is not currently in effect because the district court enjoined it, and Texas has now appealed that. That's currently pending before a Fifth Circuit merits panel. But boy, it was just by the skin of its teeth that happened. It almost did not happen. And I think how the Supreme Court dealt with this tells us a lot about the shadow docket and how the Supreme Court signals to lower courts what to do in these kinds of cases. In fact, I think you can draw a direct line from what happened in the SB 4 case to the fact that the administration's signature relief program for spouses of citizens, the Keeping Families Together program, is currently enjoined nationwide for no apparent reason. Karen is trying to fix that, but it's a very, very difficult thing, and I think you can draw that line. So let me get into it. This Texas statute, creates new criminal offenses: illegal entry from a foreign nation and illegal re-entry by certain aliens. And if those sound familiar, it's because they are a lot like the federal criminal reentry and entry statutes, 1325 and 1326. And that should tell you something about how Texas is trying to really trench on federal authority in this area. I won't get into a lot of the details, but the bottom line is that this law punishes people who would be entitled to remain here under federal immigration law. To just give one example, if you already have asylum, then that's a defense under the state law. But if you're seeking it and say awaiting a credible fear interview, it's not. If you have DACA, that's a defense. But if you are paroled, it's not a defense. Or if you have deferred action some other way, not a defense. Um, the reentry offense is even worse. It just criminalizes people who have previously been deported. What if you won your petition for review and that's the reason you're coming back? What if you waited through the time period from your deportation? Now you have a visa. The statute doesn't say that those are exceptions. There's two other really crazy features of this statute. It forbids Texas's state courts from staying a prosecution pending a federal determination of immigration status. So it's not a defense to say, hey, I have a credible fear interview or an asylum interview in just a few weeks. That's one. And then the other thing, which I think is really striking about it, is that the statute authorizes Texas state judges to order non-citizens to go back to their country if the person agrees, which sounds a little like voluntary departure, which is another thing in the immigration code that Texas is just doing on its own. Their defense of this is also sort of absurd. They say that it allows them to escort people back to the border upon agreement. So, the law is clearly illegal. It contravenes Arizona v. US, which struck down certain other kinds of state offenses that tried to criminalize employment of undocumented people, among other things, or sorry, undocumented people working, among other things. It also contravenes Chiling v. Freeman, which is a case from 1876, which struck down a California statute that essentially tried to bar the entry of Chinese women and really created the regime that we have now, where the federal government has exclusive power over who gets to come in and who doesn't. So, the story of this case is really strange. The district court issued a preliminary injunction, and then things got really strange. The Texas state, Attorney General's office appealed that order, and then they asked the Fifth Circuit for a stay of the preliminary injunction order pending appeal. But of course, when you say a stay of that, that would have meant SB4 can go into effect, which would be a dramatic alteration of the status quo in the last 150 years of federal immigration law jurisprudence. The motions panel, though, granted that request. They called it an administrative stay, and they said the merits panel should decide the stay motion. And so we're going to issue an administrative stay. And that is really outlandish. And if you want the merits panel to decide, that's fine, but you have to preserve the lower court order, or at least preserve the status quo. You can't change 150 years of law on an administrative stay. And perhaps recognizing this, they said, but we'll stay this order and give the government 7 days, or Las Americas 7 days to seek Supreme Court review. And they did. Then there were even more shenanigans. I won't get into all of it. Justice Alito did weird things with the timing and all this. But the bottom line is, at the end of that, the Supreme Court allowed the administrative stay to stay in place. And as a court, issued no opinion because it's the shadow docket without explanation. And it really would have allowed SB4, this dramatic change, draconian anti-immigrant state law, to take effect, if not for the fact that the Fifth Circuit merits panel happened to be a really good merits panel for the Fifth Circuit anyway, and they didn't want to allow this game to be played, and so they quickly dissolved the stay, held oral argument, and then allowed the injunction to go back into place. There were a couple of opinions, which I hope we'll get into a little bit, Justice Barrett's concurrence and a strong dissent from Sotomayor. But the main point I want to make here is I really think you can draw a direct line. The message from the Supreme Court was, if you want to mess around with administrative stays, as long as it's not too crazy, that's fine. And that's, I think, part of why we're in this world now that we're in, where there's been now weeks of an administrative stays nationwide stopping this massive program. And I think that's the message that I got from this case.
Thanks, Ahilan. Kate, what does this judicial whiplash over SB4 tell us about the Supreme Court's use of the shadow docket and its management of appellate courts' use of temporary stays?
Yeah, whiplash is a good term, or perhaps ping pong tennis match. But as Ahilan mentioned, there was a concurrence from Justice Barrett that Justice Kavanaugh joined. And in the concurrence, I sort of read it as her saying, stop bothering us with these administrative stays. Fifth Circuit, you go figure this out. It's kind of like a parent going to tell their kids, you work it out yourself before you bring it to us. And in that way, one could read Justice Barrett's concurrence as saying, we need to rein in the shadow docket. We need to stop opining on these administrative stays. And we're not going to, we're going to try not to get to get involved. So it was a real sort of scolding of the Fifth Circuit's management of its stay. But what I don't want to lose sight of here is the practical and tragic effect of not undoing the administrative stay. And Justice Barrett sort of like go work it out Fifth Circuit concurrence, which is that SB4 stayed in effect. And Ahilan mentioned that the Fifth Circuit acted quickly, uncharacteristically quickly, and ended up staying the case staying the issue pending appeal, and that blocked SB4 again. But had that not happened, the natural effect of the Supreme Court's order would have been that people would have been arrested, detained, and deported back to the country from which they came.
Under an likely unconstitutional state law, right?
Yeah, and that's what you really saw in Justice Sotomayor's dissent.
Yeah, absolutely. Speaking of the reasons why this is unconstitutional, Karen, Texas has made clear that it intends to basically challenge the Arizona v. US precedent from 2012 that largely struck down Arizona's attempts to create its own immigration regime. Since SB4 passed, other states, including Iowa and Oklahoma, have passed similar laws that lower courts have also found in conflict with the Arizona decision. In fact, there was a circuit oral argument just today on the Iowa law. Karen, what does this, again, back and forth whiplash over SB4 tell us, if anything, about how the Supreme Court might view the merits of the challenge to SB4?
Yeah, I mean, I think it's really important. And I would say my take is that the whiplash around the stay issue, I don't think it tells us how the Supreme Court will rule on the merits. So I'll just like answer the question directly. However, I think what should give us pause is the Supreme Court's decision in Dobbs and the Supreme Court's decision in Loper Bright, where they felt fine, and we'll discuss Loper Bright later during this webinar, totally fine getting rid of precedent that was multiple decades old, right? So US versus Arizona, of course, and to be clear, I was involved in that lawsuit. So US versus Arizona was the first of these state laws, Arizona's SB 1070, that passed in 2010, but it was one of 6 laws that passed that year. And Michelle, you and I worked on a lot of those challenges together. And to remind folks, those laws were in Arizona, Georgia, Alabama, Indiana, South Carolina, and Utah. So the 9th Circuit, the 7th Circuit, the 10th Circuit, and the 11th Circuit. And guess what the outcome in every one of those cases was? That the laws were resoundingly unlawful. They violated the Supremacy Clause in numerous ways. And we ran the table, right? And ultimately, the US versus Arizona case is the Supreme Court precedent. But now we're in the middle of a second spike of these copycat anti-immigrant laws, right? The Iowas and the SB4s. And all under a very clear desire led by the state of Texas, but joined by other states, to literally take on and ask a Supreme Court who has said, hey, we're willing to toss out our precedent to do so here. The last thing I'd say, because I know we want to get onto the other really interesting shadow docket case, is this is what I think could stop the Supreme Court from reversing the Arizona precedent, which again is so important, not just in this area of state laws that are anti-immigrant, also super important in terms of enforcing discretion of the executive and deferred action, just to be clear. If the Supreme Court reverses this precedent and says it's open season on states passing these kind of immigration laws, guess what? It's also open season on a different flavor of states passing pro-immigrant laws. And so I think that is something that will give the Supreme Court pause if they are ready to lift US versus Arizona precedent.
Thanks, Karen. I'll pass it to Kate for the next case.
Yeah, I like that spin on it, Karen. That gives me that gives me some hope. The second immigration-related case that arose on the shadow docket in the past term had to do with Texas's placement of concertina wire or razor wire along stretches of the Rio Grande River in Eagle Pass, Texas. Texas sued the U.S. federal government seeking to stop agents from removing that razor wire that Texas had installed. And Texas installed this razor wire as a part of the larger Operation Lone Star campaign. Texas sought a preliminary injunction to stop the federal government from removing this razor wire, and the district court denied that preliminary injunction. Texas then appealed that decision and sought an injunction pending appeal. And the Fifth Circuit in December of last year granted that injunction pending appeal. So if we're still trying to figure out where the whiplash is, that meant that the federal government had to leave the concertina wire in place during the course of the appeal. The federal government then filed an emergency application to the Supreme Court to vacate the Fifth Circuit's injunction pending appeal, i.e., to allow it to remove the razor wire as needed. Now, while all this was happening, the state of Texas put up new fencing extending further into Eagle Pass, Texas, and into an area known as Shelby Park. And that part of Eagle Pass was where Border Patrol was launching its boats into the river. Texas National Guard, along with the National Guards of other states that were supporting the Texas National Guard, started refusing to allow the Border Patrol access to the Shelby Park area. Some of you may recall seeing the videos and pictures setting up this conflict between state National Guards and the federal government, the Border Patrol agents. Tragically, 3 migrants from Mexico, a woman and 2 children, ages 8 and 10, drowned on January 12th in the Shelby Park area. Texas officials had denied federal officials access to Shelby Park, even after Border Patrol had received reports of migrants in distress in the river. A couple of weeks later, the Supreme Court vacated the Fifth Circuit's injunction pending appeal by a 5-4 vote, restoring federal officials access to the river and ability to remove the razor wire. But Justices Thomas, Alito, Gorsuch, and Kavanaugh would have denied the federal government's application. Chief Justice Roberts and Justice Barrett joined the liberal justices in vacating the injunction and restoring the federal government's rights in this area. I want to step back because this case really illustrates how important these shadow docket cases are. The Fifth Circuit heard oral argument on the merits of this case in June, and we are still awaiting a decision now at the end of September. So had the Supreme Court not dissolved the stay, the federal government would have been barred for the last 9 months from accessing this area of Eagle Pass and removing the razor wire. And I just want to note as well that the razor wire case is not the only case involving physical barriers that Texas has placed along the Rio Grande. Texas has also installed floating buoys, complete with saw blades, to deter migrants from crossing the river. In the buoys case, we saw the reverse, where the U.S. government sued Texas to remove the buoys. An en banc Fifth Circuit handed Texas a win on July 31st when it vacated an injunction that had required Texas to remove those buoys. Now, it was on some technical grounds about the Rio Grande and whether it was a navigable river within the meaning of an 1899 statute. It's a captivating read. But what I want to focus on is the fact that the buoys case also raised the state of Texas's very incendiary and dangerous invasion claim, i.e., that a migrant invasion was occurring that allowed the state government to take action independent of the federal government to defend itself against quote unquote invaders. This argument has also come up in the SB4 case, and while it has not received any endorsement in the majority of opinions, we have seen this invasion claim feature in dissents from Judges Oldham and Ho. And so sadly, we are seeing ink being spilled on this very harmful invasion claim.
Thanks, Kate. As you know, this razor wire case presented really dramatic facts and a clear confrontation between state and federal authorities, unlike what we've seen in probably decades. And yet 4 justices, as you know, it would have allowed the Fifth Circuit's order to stay in place and block the federal government from removing this wire and accessing important stretches of the border. What happened in this case provide any clues about how the court will treat future state and federal disputes over immigration?
Yeah, I think we can't read too much into what justices do on these stay applications or dissolving stays. But I think we can absolutely assume that the 4 justices who were in the dissent want to give states more power to regulate immigration. But what I'm more interested in watching is what Chief Justice Roberts does with regards to these cases around state versus federal powers over immigration. In the past, Justice Roberts has played the role of the institutionalist, but we've really seen a departure from that over the last 2 terms, especially last term. And I think it started with the Dobbs case. And so, I'll be watching how Roberts handles these state federal cases in light of the longstanding case law that both Karen and Ahilan have talked about. Will he play that institutionalist role, upholding precedent, upholding stare decisis, or will he continue to side with the conservative majority, tossing aside essentially a century and a half of settled case law?
We'll see. Ahilan, could you comment on this so-called invasion defense that Texas is invoking? Why is this so dangerous, both as a legal doctrine and also rhetorically as a justification for violence against migrants?
Yeah, I love that I get the dystopian role in this. The invasion argument, which is, as Kate mentioned, in a concurrence from Judge Ho in the Buies case, on the one hand, it is, in my view, frivolous. It's frivolous to call what's happening at the border an invasion. But it is also terrifying because it is all over the political sphere. It's what Trump is saying in all of his stump speeches. And now it obviously isn't just limited to that. It's not, several states have issued essentially invasion like declarations or emergency declarations on this basis. I say it's frivolous because it's very clear both at the founding and sort of in normal usage that an invasion is armed hostility from another political entity on US territory. Like that's what an invasion is. There's some great writing on this on Just Security on the Just Security blog site, by the way, if people want to look. Some people have done deep dives into this. And Judge Ho doesn't really explicitly dispute that, but instead he says that whether any given conduct rises to that level is a non-justiciable political question. And that reminds me of other kinds of arguments that were made. Justice Scalia said in Hamdi, the enemy combatants case, that whether the 9/11 attacks constituted an invasion was for Congress to decide. And it kind of has that echo a little bit. I say it's terrifying because invasions authorize all kinds of things, as they should if they're actual invasion. One thing is you can suspend habeas corpus. Under Article 1, Section 9, the suspension clause has, except when in cases of rebellion or invasion, the public safety may require it. And so you could imagine mass arrests, mass deportation, arising from mass arrests happening if there were actually an invasion declaration and an argument that the courts could not interfere. Invasions also authorize military force to repel them. Again, like obviously, but who knows? Could this justify the state taking its own kind of cross-border military action or federal military intervention into Mexico? This stuff sounds crazy. I know it sounds completely crazy, but we have seen other things that are crazy, and then a few years later they end up, very real. So that's one of the reasons I'm very concerned about that idea.
Thank you, and sorry to stick you with that depressing question. Karen, there's another case pending at the Fifth Circuit right now that is likely to make its way or could make its way to the Supreme Court on immigration issues, of course, on the shadow docket. That's the conservative state's challenge to the administration's Keeping Families Together parole-in-place program. Can you describe this case, its current status, and the role of the private parties that you're representing to defend the program?
Yeah, of course. And maybe this is the more depressing question. Who knows? But so the Keeping Families Together program, as folks know, created parole in place for individuals who do not currently have status in the United States, have been here at least 10 years, and are married to a U.S. citizen as of June 17th, 2024. And the program opened to applications on August the 19th. That was a Monday. And on Friday of that week, Texas and other states, 16 states total, filed both a lawsuit in Tyler, Texas, which, as someone who grew up in Texas, Tyler, Texas is the rose capital of the world, I'd like you all to know. It is also the home of the Plyler versus Doe decision, and it is about an hour and a half outside of Dallas. And so they filed there where there are only 2 judges on the wheel. They are both Trump appointees, and they drew Judge Barker, who you can check out his Senate questionnaire. He previously worked for the AG's Office of Texas and authored briefs at the Supreme Court challenging the DAPA program and in favor of the Muslim ban, among other notable issues. So the case went to Judge Barker, and it was a Friday. And on Monday, we, on behalf of 11 applicants for Keeping Families Together and CHIRLA, sought intervention. That would be the first business day after the lawsuit was filed. We filed our intervention motion, all the things you have to file with it. And a couple hours later, the court issued sua sponte, an administrative stay on the Keeping Families Together program nationwide, shutting it down. To be clear, his order said applications can be accepted, and he used the following word, and reviewed, but that there cannot be grants of parole in place under the program. So that's really interesting. And USCIS has interpreted that to allow biometrics to continue and other things that would have applications ready to be granted should the program ever reopen. Okay, how did we get to an administrative stay? Well, that's a really good question. And maybe it has to do with what we've been discussing already, because Texas sought a TRO, right? They sought a TRO. They didn't ask for an administrative stay. The US government immediately on the same day said, hey, Your Honor, there's a bunch of things we want, including discovery, but please don't do anything and issue any schedule orders without having a status conference. The court there's been no hearing, no status conference on this case, just to be clear. So the court went ahead and issued this administrative stay, that's what he called it, with no analysis, right? If you're going to order a preliminary injunction or a temporary restraining order, we all know what you need to do. There's 4 steps under Winter that you're supposed to balance, right? You got to show your homework if you want to block a nationwide program. That didn't occur. So the US government and we as amici, because we had been denied intervention, very quickly in the next week, we had to file for our intervention, we were denied, sought to vacate this stay. And in response to that filing, the court extended his stay, the district court judge extended the stay to September 23rd and shortened the schedule for the trial. And so to be clear, before we appealed to the Fifth Circuit, what had happened is that the judge had set a schedule for 3 weeks from the filing of the lawsuit to a trial, a bench trial on the merits, including a 3-day discovery period. Now, those of you who litigate regularly know that that's absurd, that it is truly absurd to think on a case this big where standing is being contested and there's like factual evidence that needs to be exchanged in an administrative record to go from filing to bench trial with all the stuff in between in 3 weeks. We sought immediate an appeal of our denial of intervention because of what was happening on a fast track at the district court and how that looked to be designed to not produce a good record below. We asked for expedition of that appeal. We were very clear that we wanted it all wrapped up before the trial that was set for the 18th of September. So if you're tracking this math, back in the day, the stay was supposed to lift on the 23rd of September. The trial was supposed to happen on the 18th, but the Fifth Circuit got excited and they decided that they were going to issue their own stay, which they did. They stopped all proceedings in district court, issued their own administrative stay. Again, no homework. Nobody is balancing any of the equitable factors here. Nobody's talking about who's likely to succeed on the merits or all the things that you should do when you block a program. And then scheduled our intervention appeal argument for October the 10th in New Orleans. So the stay will remain in place at least that long. What is wrong with that? Well, it goes real simple like this. TROs are supposed to be in place for 14 days with one chance of extending them. 14 plus 14 is 28. So come day 29, if you're a district court judge or a circuit judge, you ought to have shown your work and done the legal analysis that's required to justify this extreme remedy. Day 29 was September 23rd. And so that is what has happened. But right now, we have moved to vacate the stay at the Fifth Circuit. The United States has moved to vacate the stay at the Fifth Circuit. I'm sure we'll be talking about that in oral argument, even though the oral argument is supposed to be on intervention. But somewhere, someone ought to show their homework. And I do think that if that doesn't happen and the stay continues in place, like the stays we were talking about earlier from the Fifth Circuit, that this case could potentially head on the shadow docket to the Supreme Court. So that is the long tail of where Keeping Families Together is today.
Thanks, Karen. Incredibly frustrating. I know we could probably say a lot more about the shadow docket, but given time, we wanted to move into some of the merits cases that were heard last term at the Supreme Court, starting with the immigration specific cases. So I will pass it again over to Kate.
Thanks, Michelle. And we're going to start by talking about one of the big cases, which was Department of State versus Munoz. And this case is about the rights that a U.S. citizen is entitled to receive and information they're entitled to receive when a consular officer denies their non-citizen spouse a visa. So at the center of this case is Sandra Munoz, a U.S. citizen, and her husband, Luis Asensio Cordero, who is a citizen of El Salvador. They lived together in the United States, and Ms. Munoz filed a spousal visa petition for Mr. Cordero. In order to get that visa, he had to go through a process called consular processing, which involved traveling to El Salvador to receive the visa. And I'm simplifying for the immigration practitioners on the call. I'm kind of glossing over some steps, but for the sake of time, he had to go to El Salvador, and that's where he ran into problems. Once there, a consular officer denied his visa on sort of vague grounds under a statute INA 212A. That makes a non-citizen admissible if the officer has reason to believe or knows that the person will commit criminal activity in the United States. And as you can imagine, reason to believe can be stretched. And suspecting that Mr. Asensio Cordero's tattoos were a factor, the couple submitted more information to the consulate, including expert testimony about those tattoos and what they were about. It didn't change the decision. The consular officer continued to refuse the visa, and so the couple went into federal district court in California. There, the federal district court sided with the government, but then the Ninth Circuit of Court of Appeals reversed, and they sided with Ms. Munoz, saying that she, as a U.S. citizen, had a constitutionally protected liberty interest in her husband's visa application. And that liberty interest entitled her to more due process. She was entitled to get more information about why the visa was denied and was entitled to judicial review. And the Ninth Circuit said the government could not invoke a doctrine typically used to shield judicial review in U.S. courts. And that doctrine is called the doctrine of consular non-reviewability. Around the same time, the DC Circuit issued a similar, though not identical, or the DC Circuit handled a similar, though not identical case, but came out the other way. So when the U.S. government went to seek certiorari before the Supreme Court, they granted the case to resolve this issue. And in a 6-3 decision authored by Justice Barrett, the Supreme Court reversed the Ninth Circuit, holding that a U.S. citizen has no fundamental liberty interest that entitles her or him to more due process. In reaching the conclusion, Justice Barrett relied on a due process analysis from a case called Glucksberg. And that case first asked, what is the nature of this fundamental right that's asserted? And this is where Justice Barrett, writing for the majority, and Justice Sotomayor, writing for the dissent, disagreed. Justice Barrett said this is about the right to bring a non-citizen spouse to the United States, and Justice Sotomayor said, no, this is about the fundamental right to marriage. Justice Barrett then proceeded to find the right to bring a spouse to the United States and reside with that spouse in the United States as not deeply rooted in the nation's history and tradition. And because there was no fundamental right, she was not entitled to additional information, additional due process, or federal court review.
Thanks, Kate. The Supreme Court could have ruled for the government in Munoz without deciding this question of the U.S. citizen's liberty interest. In fact, Justice Gorsuch pointed this out in his concurrence in judgment, and the dissent pointed this out as well. Why did the court take the extra step of finding that no liberty interest exists?
To make us immigration litigators extremely frustrated? No, yeah, that's right. In the course of the litigation, the plaintiffs did receive more information about the visa denial, and that could have been enough to end the case. The court I suspect, I'm guessing, likely went further because this is a part of a larger effort to curtail fundamental due process rights. And I think this is a court that does not shy away from deciding more than it has to when it amounts to curtailing civil rights and liberties. And sadly, unfortunately, I think we will continue to see this trend prominently in the area of immigrant rights. And so I think for immigration and federal court practitioners on this call today, this is a cautionary tale about which cases we take to the Supreme Court. And, we can't always expect that they will narrowly tailor their decisions.
But as you know, it was the Biden administration that took this case to the Supreme Court. Can you tell us why? This seems to at least contradict the spirit of, let's say, the Keeping Families Together program, even though they're totally different factual settings. So why did it go to the court on this?
Yeah, well, we don't have any inside knowledge on why it went to the Supreme Court, but I suspect it's because the Department of State really wanted to push to try to curb judicial review of consular officers' decisions. We're talking about officers in overseas embassies and consulates who don't spend a whole lot of time on these visa applications. And so I think the Department of State was saying to the Solicitor General's office and to DOJ, we need to take this up to the Supreme Court. We need to resolve this. And I think you're right that there is a real conflict with the spirit of keeping families together. Now, these two things are a bit of apples and oranges. Keeping families together is about giving parole in place to long-term non-citizen spouses. And the Munoz case is really about what processes do. But I think it really is an inconsistent administrative decisions by the Biden administration. And I'm very happy about keeping families together. I'm very disappointed at the broad arguments that the government made in Munoz.
Thanks. Ahilan, we saw in this case some troubling use and misuse of racist and sexist immigration law history in the opinion. Can you discuss some of these sexist and racist marriage-based immigration restrictions in our immigration law?
Yes, but I should say just one thought on Kate's answer to your prior question. I'm sure the State Department was pushing for this. But it's also true that the DOJ has consistently, in both Democratic and Republican administrations, pushed to decrease the constitutional rights of immigrants in a variety of cases, and they've done that consistently on both sides. Anyway, we'll get into lots of examples of that, but you can certainly find examples of that in this administration and in the Obama administration as well. There's a couple of passages in this opinion which really make the claim that the founders thought that the federal government had the power to exclude non-citizens. And if you look at those passages closely, they really are some of the worst misuse of history that you will see in a Supreme Court opinion. The first line of the first part of this quotes Madison. And Madison literally thought the opposite. In fact, in the passage, if you look at the full context, he's describing the other side's argument about whether the federal government has the power to exclude people, and then he goes on to answer it. They also cite the debate on the Virginia resolutions, which Madison was heavily involved in. They quote a page which is actually from the losing side. The majority conclusion in the Virginia resolutions was that the Alien Friends Act was unconstitutional because the federal government did not have the power to regulate immigration. And I could go on. I mean, the other evidence that they cite there is really terrible. Then the next paragraph, to sort of go directly to your point, they talk about Chinese exclusion era statutes. And they rely on a quote from the Emergency Quota Act of 1921, and before that, a Chinese exclusion era statute. That too, I mean, one thing is that the quotes are sort of wrong and to some extent out of context. We actually filed an amicus brief with other law professors pointing out that if you look at the history, even of these really terrible racist, sexist laws, many of them did actually treat spouses of citizens differently. And that's really all that Munoz was trying to show, not that spouses have the right to immigrate or something like that, unfettered, unconditional, but that there were differential treatment for them. And they were in fact treated differently in a bunch of these. But I think also it's like a more basic question: why exactly is it appropriate and good sort of jurisprudence to rely on history from a time when women were property, treated like property? The Chinese exclusion era cases, they cite Wang Wing for the claim that the US can, as a matter of public policy by congressional enactment, forbid aliens or classes of aliens from coming within their borders. And then it says like ... no limits can be put by the courts upon the power. And if you look at the whole quote, it says no limits can be put by the courts upon the power of Congress to protect, by summary methods, the country from the advent of aliens whose race or habits render them undesirable as citizens. That's actually the full passage that the court is a ellipse of which they are relying on. So really just starkly present this question, like really, that because we treated women as property and therefore allowed them to be expatriated when they married non-citizens, therefore that's the tradition that we get to look to figure this out. And this is, it's just a very serious problem with the use of history more generally. Obviously, you get similar problems like this in other contexts, but it's a very serious problem in immigration cases because so much of the history of immigration law in this country is a deeply racist and sexist history. And this is just like another example of the court kind of doubling down on that in an unfortunate way.
One more question about this case. I think it sort of flew under the radar outside of our immigration circles, but some of the issues that came up in the dissent, I think, may resonate more broadly with folks, including the alarm bells that the dissent raises about how the Munoz case undermines the fundamental right to marriage. It invokes the court's 2015, so only 9-year-old opinion, the Obergefell decision, holding that same-sex couples have a fundamental liberty interest in marriage. It also invokes Loving v. Virginia, which of course struck down state laws that prohibited interracial marriage. And it brings up Dobbs and the fact that just 2 terms ago, Dobbs, basically said, no, this isn't going to go further than this other precedent is fine. You're on stable ground. This is only about the right to abortion. Kate, should we be concerned that the Munoz decision further erodes liberty interests, including the right to marriage that we understood to be protected by substantive due process?
Yeah, I wish I had better news, but I think we absolutely should be concerned. And I would really encourage people to read Justice Sotomayor's dissent here, in which she says, you told us 2 terms ago in Dobbs that this would not be this gradual creep into different fundamental liberty rights, and yet here we are. This case is about the right to marriage. This isn't about the right to bring your spouse in the United States, bring your spouse and live with your spouse in the United States. This is about the right to marriage. And I think this is something we saw throughout the term, especially with Justice Sotomayor and especially with Justice Jackson, in their dissent saying, no. Let's call a thing a thing. This is what this is about, and this is a continual creep into the rights of marriage. And I think we should all be on high alert for what might happen to Obergefell.
Thanks, Kate. We have to move on to another case, although again, we could discuss a lot more. The next immigration law case from the last term we want to talk about is the Campos-Chavez v. Garland decision. And this case is the 3rd in a trilogy of pretty recent cases involving the requirements for a notice to appear, the NTA, which is the document that the government must provide a non-citizen it's attempting to remove from the country. And the NTA is supposed to notify the individual of the factual allegations and the legal basis for their removal. Now, the court had very recently discussed the requirements for an NTA, first in Pereira v. Sessions in 2018, and then in Neitz-Chavez v. Garland in 2021. The Pereira decision was in 2018, 8-1, authored by Justice Sotomayor, holding that when an NTA does not have the time or place of the scheduled immigration court hearing, it's not an NTA at all. And then it can't trigger what's called the stop time rule for purposes of cancellation of removal, which is a remedy available to certain non-citizens who have been in the country for a designated amount of time. Now, normally, when they're served with an NTA, this stops the clock on the accrual of time for them to have continuous presence and be able to avail themselves of cancellation. But the court said in that case, only if the NTA meets certain statutory requirements. And Pereira made clear that when a NTA does not include that information, it's not in compliance with the statute and can't trigger the stop time rule. Now, following the Pereira decision, the government continued to issue non-compliant NTAs, lacking this information, and the court had to take up the issue again in Nice-Chavez in 2021. And there, in a 6-3 decision, Justice Gorsuch authored the opinion holding that to trigger the stop time rule, DHS has to serve on the non-citizen a single document, NTA, containing all the information about the removal proceedings. So in other words, it can't cure an initial NTA that was non-compliant by providing a subsequent notice about the time and place of the removal hearings. But this was again in the context of cancellation and the so-called stop time rule. So it was an extension of Pereira. And that brings us to the Campos-Chavez case from this term. In the wake of those two decisions, advocates had argued that the same rule should apply outside of the cancellation of removal context. So in other words, defective NTAs should have consequences on the government and the government's efforts to remove a person from the country. And the argument was basically if the government had to strictly comply with the requirements of the statute for NTAs to trigger the stop time rule, it should also have to comply with the statute for purposes of removing a non-citizen in absentia, which means when the person doesn't appear for their immigration court hearing, the immigration judge can enter an order removing them in absentia. After Nice-Chavez, the circuit split basically had emerged, with some circuits finding that a defective NTA alone provided grounds to rescind an in absentia order, while the 11th Circuit found the opposite. So that brings us to Campos-Chavez this year. And unfortunately for immigrants and their advocates, Justice Alito authored this opinion in a 5-4 decision, holding that a defective NTA alone was not sufficient to rescind an in absentia removal order, so long as the non-citizen afterwards received the notice of a hearing at which they were ordered removed. In Campos-Chavez, the non-citizens had initially received non-compliant NTAs, in other words, NTAs that lack the date and time of their removal hearing, but they had separately and later received notice of a hearing, and that was the hearing that they missed and were ordered removed. Interestingly, Justice Alito's opinion in Campos-Chavez barely mentions Pereira and Nice-Chavez. It sort of waves away Pereira's discussion of the statute, discussing the requirements for when the government wants to make a change to the hearing date or time. Just saying basically it was dicta, it was not part of the holding. And Justice Jackson wrote a dissenting opinion joined by Sotomayor, Kagan, and Gorsuch, noting basically that the court is blessing the government's abject non-compliance with the statute's unequivocal command. So pretty strong dissent, calling out the court for allowing the government to continue with these practices. So here we are at the third of the 3 cases and reaching this result. So I'm curious, Kate, if you can talk about why, Justices Barrett and Thomas had been in the majority in Nice-Chavez, and Justice Thomas, before Justice Barrett was on the court, was in the majority in Pereira, all siding with the non-citizen. But here they are on the other side of the issue now. What can we glean, if anything, from these justices now siding with the government? And does this represent a retreat from some of the textualism analysis from Justice Gorsuch's opinion in Nice-Chavez?
Yeah, what I would suggest that we can glean from this is that where you have 2 competing arguments around the texts, I think the Supreme Court is going to side with the interpretation of text that is going to make it easier to remove non-citizens. And what we saw here is the Supreme Court pointed to a part of the statute that says you can't undo an in absentia removal order, if either you received a compliant NTA or you later received notice of a hearing, time and place of the hearing. And they said, well, it says or. or you later receive notice. And all the petitioners in this case did receive notice. And so therefore, looking at the text of the statute, this is fine. Justice Jackson, however, says, how can you modify a notice when you don't even have a compliant NTA to begin with? And she really goes into how this elevates form over substance in a way that just is untethered from reality and untethered from the purpose of the statute. And so I don't know that textualism is dead, but I do think that where you have competing versions of the text, we have a Supreme Court right now that's going to pick the version that's going to favor the government and harm the immigrant the most. And that's what's, I think, the most frustrating about Campos Chavez.
Just really briefly, I'll note that there are still avenues to pursue rescission of an in absentia removal order post Campos Chavez, but they'll likely require showing that the person failed to receive notice of the hearing that they missed and were ultimately ordered removed at. And I'd recommend the council and NIP NLG practice advisory on these issues for some strategies going forward. And with that, I'll pass it to Ahilan for discussion of the next merits immigration case.
Finally, some good news. I'm going to talk about Wilkinson v. Garland really quickly. Mr. Wilkinson is an immigrant from Trinidad. I had a son with severe asthma who was 7 years old at the time of the relevant events in question. He'd come on a visa, overstayed it, then was actually arrested on drug charges that were later dropped. And at least the way the opinion describes it, it sounds like it might have been like entirely a mistake. But the government nonetheless proceeded in seeking deportation based on the fact that he had overstayed the visa. He lived here for longer than 10 years, so he was eligible for non-LPR cancellation of removal if he could show an extraordinary and extremely unusual hardship for, in this case, his child, and also the mother of his child was also a U.S. citizen as well. The immigration judge held that he could not make that showing, and so then the question that he filed a petition for review, and the question was whether that determination that he failed to meet the extraordinary and extremely unusual hardship requirement for cancellation was reviewable on a petition for review. And the Supreme Court said it was, that in general, discretionary determinations are barred from review under 1252A2B, but there's an exception for questions of law. Essentially, it's like carves back out review even where it's otherwise precluded under 8 U.S.C. 1252A2D. And the court held that this mixed question, whether something qualifies extremely extraordinary, extremely unusual hardship, is a question of law. It's a mixed question of law, but it's still a question of law, and therefore is reviewable under A2D. They said, look, if it's more factual in any given instance, the kind of determination feels like it's more about the facts, that may require greater deference because the fact finder gets deference, but it's still reviewable. And so you can't say there's no jurisdiction entirely. This case is really interesting, and it's obviously very important for the class of people who are trying to seek judicial review over cancellation denials. It's the third in a string of recent cases about what questions are reviewable in petitions for review. Guerrero Lasprilla had held that the question whether immigrants had acted with due diligence in seeking to equitably toll the motion to reopen deadline was reviewable because that was a mixed question under A2D. Then Patel had, after that come out the other way, said factual findings in removal proceedings involving discretionary relief are not reviewable under A2B. And actually next term, at the end, we'll talk about this, is going to be another case, Buarfa, which is not arising from a removal proceeding. It's a revoked marriage petition, but it's another question about the scope of these statutory bars, A2B versus A2D. So, the court said that the result here was closer to Guerrero Lasprilla, really dictated by Guerrero Lasprilla, and that Patel was distinguishable. It rejected the government's argument that essentially primarily factual mixed questions should be treated like factual questions, or that they are not within A2D, and rejected some other sort of technical arguments I don't think we need to get into here. For me, the big picture about this case is a very important, win, as I said, in this sort of class of cases, and I think, the broader lesson I would draw is SCOTUS has been terrible on constitutional immigration cases in all respects. We've heard about some of those today. In the jurisdictional side, Thursingham from a few years ago is still, I think is one of the worst judicial review cases in the history of the whole court, and sort of effectively reversing St. Cyr and all these terrible things. But on statutory questions, it's much more like a coin toss. Going back to Kukana, and then these other cases, it really it depends. Sometimes they find that there is judicial review, and they're more inclined to favor the presumption favoring judicial review. The lineup's also interesting. It's 6-3 with Roberts, Alito, and Thomas dissenting. And then Jackson has this interesting concurrence. I guess we'll get into that a little bit now, but it's an interesting and important case.
Thanks, Ahilan. Karen, what can we make of Justice Jackson's concurrence and her skepticism that Congress intended questions like this to be reviewable?
See, now here's when the conversation takes a bad turn. So the Justice Jackson concurrence, and this is something for me, like, I don't yet have enough data on the two most recent women who are Supreme Court justices to be able to really talk about, like, how do they view immigration issues? Like, how are they going to be as jurists? So both Justice Barrett and Justice Jackson. And Justice Jackson, right, when she was nominated and we looked at her immigration cases in the DC Circuit, there weren't a lot of them, you all. But boy, oh boy, is this short concurrence worth a read. Here's what she says. So she's in the 6, right? And she says, I agree. Okay, I agree. However, I'm writing separately to address one thing. I don't think this is the kind of question that Congress meant for courts to review, which honestly is kind of like she's asking for a do-over of her vote in some way, right? And then she goes on, she says, literally, court stripping provisions are supposed to mean something. And the court stripping provision in IIRA that said there are only certain questions that can be reviewed here, it needs to have teeth. And this is a bit of an end run. If mixed questions of law and fact, and not just constitutional questions or pure questions of law are reviewable, like, where's the end game? And are we taking Congress seriously about what they intended to strip from the court's jurisdiction? I'm not convinced we are. Of course, Congress is free to revise its law, to revise this provision if they think we got it wrong. So honestly, I found that a little bit chilling, right? Because ever since 1996, decisions like this is what we live for, right? Okay, the ultimate determination is discretionary, but there are certain legal questions that are reviewable and where we can really, argue on behalf of our clients. This is a great result. But this concurrence has me troubled, and it leads me to believe that Justice Jackson is going to be very skeptical when she is confronted again with other court stripping provisions within immigration law.
Thanks, Karen. Let's transition to talk about some of the non-immigration cases the court decided this term that are bound to have significant impacts in the immigration world. I'll pass it back to you, Karen.
Yeah, so we wanted to talk a bit about Loper Bright, the death of Chevron. It's not like you were all surprised. Everybody saw this coming, but let's try to spend a little bit of time unpacking it. And I will say that, I read the decision when it came out and then reread it in preparation for this webinar. And, I'll just be candid. Like, I was muttering to myself as I read the majority opinion. And it really is staggering for nothing more than the judicial power grab that it is. So what in the world is this Loper Bright case? Loper Bright is a couple of consolidated cases involving fishing regulation. That's right. At a bottom line, the issue in question was, do the vessels themselves have to pay when a monitor from the federal government goes on their vessel? Yes or no, who pays the bill? That was what was being challenged, but it became a vehicle for challenging Chevron deference. So Chevron, as we all know, was, until this decision, in place for 40 years. That is a very long time. We all have had to confront Chevron in our own litigation, but there were certain bedrock principles that came from Chevron that we used to think were true. This is what they were, in my opinion. Congress can't write a perfect statute. There's always going to be some ambiguity. And we courts believe, that when there is ambiguity in the statute, it is appropriate to defer to the agencies, because agencies are experts in the subject matter, and they're going to do a better job filling those gaps than we as courts are going to do, because we are non-experts and we are not policymakers. That's like what we all learned in admin law, right, everybody? Like, that's what everyone thought the world was, and we had to work within it. And the decision by the chief flips that on its head. And he does it in this way that actually is reflective of some of the other cases we've been talking about. He says, oh, let me actually tell you what the history of both Chevron and the Administrative Procedure Act is. Now, the Administrative Procedure Act is 80 years old. And so we probably knew what the history was before, but Chief Justice Roberts lays out that actually what we all should have known, even when Chevron was passed, was no, that APA wanted to be a check on executive authority through agencies, and that courts always sense, and yes, the Federalist Papers get cited quite a lot in this opinion, courts have a sole responsibility to tell us what the law means. But that's what happens in this case. So it's a real head scratcher, right? Because what happens to all the other cases? Thousands of cases, as Kagan tells us in dissent, that relied on Chevron. And we hear a little from the chief, and we're going to talk about it. And he says, oh, well, okay. It doesn't mean our decision today that Chevron is dead and we are reversing it, that all the cases that relied on Chevron also should be tossed out. He essentially says, it depends. It depends how Chevron was applied there. And the one thing that I'll say before I pass it to you, Michelle, to kind of lead us in a discussion of how does this impact our world, and are there more opportunities or more pitfalls now that Chevron is dead, is, look, Chevron was tricky, you guys, right? Chevron was supposed to operate as step one and step two. Step one, is the statute ambiguous? If it's not ambiguous, you never even get to agency deference, right? But we all know that two things happened. Number one, there was like an invented step zero that was never really part of Chevron that shows this was not a stable precedent. And then secondly, I think we've all had this, and we could take off the cases where it was the case. It was a judge who was deciding if the statute was clear or not. And you can make lots of arguments that the statute is clear and it is the way that you think it is, and obviate the need to ever get to a deference of agency interpretation. So I do think there was something quite problematic about Chevron as it had been applied that the court was trying to address. But this decision does smack, I think, of, as Kagan calls it in her dissent, she says, we've replaced judicial humility with judicial hubris. And I would pass it to you, Michelle, to lead us through the discussion.
Thanks, Karen. Start with Ahilan. Chevron deference had fallen out of favor, particularly the Supreme Court, not as much at the lower courts in the past several years, but still the formal overruling of it is a sea change in administrative law with potentially significant impacts in various areas of progressive litigation, including the immigration world. What are the areas in which immigrant advocates may see new openings for challenges post Loper-Bright?
Yeah, and I should say, as a whole, hearing so many people talk about the horrors of the end of Chevron is slightly odd for me, like having, and I'm sure for many other immigrants' rights litigators, having spent so much of our careers trying to litigate against terrible agency interpretations of the immigration statutes that were harming our clients. And I definitely agree with Karen's account that it's bizarre that a ruling would sort of overrule the APAs from so long ago and all those sorts of things. But there's a lot of opportunities here, I think. I mean, one way to think about it is every case. So we didn't talk about Brand X, right? But Brand X was one implication of Chevron, was that even after, say, a circuit court had construed a statute, if the circuit court, if the agency understood the circuit court to be interpreting the statute to fill a gap or, address an ambiguity in the statute, then in theory, the agency might have the ability to resolve that the other way, because it was ambiguous. And so, the agency could essentially overrule the circuit court decision or even a Supreme Court decision. And that happened. And there were a number of cases like that where a circuit court went one way, then the agency went the other way. And in some of those cases, the circuit court came back and said, oh yeah, you're right, it was ambiguous. And so we're now flipping our precedent. In other situations, they didn't. They said, no, you've got it wrong. Actually, our first decision was based on step one. And so you can't actually reverse us here. But if you look at the ones where that happened, in all of those situations, you're going to have prior circuit court precedent that ruled one way, and then the agency came back and did something, the other way. Now those are, you would think, open because the agency's determination was not entitled to, it had been entitled to Chevron deference before, and you've got a pre-existing interpretation of how the court would have done it in the absence of Chevron, and that is a very good guide in how you'd expect the court to rule now. So one example is I was sort of hunting and found out, in the 10th Circuit, whether a non-citizen subject to the 10-year bar can adjust under 245I, which is potentially a very important question, right? Like for people who are eligible because they had a petition from before April 30th, 2001, but then, are subject to the bar. That's an issue where the 10th Circuit had come out with an immigrant-friendly rule. Then the agency had gone and reversed it. And then the 10th Circuit had then upheld the agency's interpretation, at least as to, post BIA decision petitions. And now that seems like quite ripe for attack. Another ground, cases that are decided by summary affirmance. Because I think we're going to get into this in a second, the form of deference which is available now, Skidmore deference, is rather than Chevron, what's sort of replacing it is based on the quality of the reasoning of the agency decision. Well, if it's a summary affirmance or if it's something it's very quick or shoddy, then that might suggest that it's actually not entitled to much deference. And so then again, it's another space where you could go back and attack. I haven't done a kind of comprehensive review. I hope someone's doing it already. If not, somebody really should. You go back and spend some time, citing, looking for all these different rules. There's lots and lots of rules where the agency was given deference in the Court of Appeals that were unhelpful, that are at least potentially subject to attack now.
Yeah, let's dig into this issue of precedent decided under Chevron a little bit more. Karen, you mentioned this sort of cryptic paragraph in the Chief's opinion about how prior precedent decided under Chevron should be treated going forward. And he specifically said Loper-Bright does not call into question prior cases that relied on the Chevron framework, and that those cases are subject to statutory stare decisis. What does this all mean? Where does it leave us? How can we go about challenging prior precedent that may have been decided under Chevron, given that it really is a total sea change in the way statutes are analyzed?
Yeah, I think it doesn't tell us much, you all. That's what I think, right? I think this acknowledgement is necessary because when you reverse a 40-year-old precedent, right, and obviously the dissent points this out, thousands upon thousands of cases relied on Chevron. You don't want to throw all of that into chaos. However, it is a bit in chaos. And I think we're in a period where the fallout is going to percolate back up to the court. I think that the easiest way, though, to understand this is really about how was that prior case decided, right? If the prior case relied on Chevron to say, there's no ambiguity, the law is clear here, aces, there's nothing to challenge, right? That's what the majority opinion says. Anyway, the courts shall decide, no deference is really required. I think you have a very narrow road to a possible overturning of that, either case directly or the precedent kind of within the circuit. I think where things get real interesting is what in the world happens if the court expressly got to Chevron step 2? Then what? Then I think all bets are off, right? So if the court got to Chevron step 2 and relied on agency interpretation, then that seems to me that it is plausible to argue that the issue or case could be relitigated if there's still, all the things that you would have to show, case and controversy, not moot, etc. But that's an entire category of cases across an entire range of administrative law subjects where I think we are no longer in certainty. And I think that if you are litigating a case like this, a statutory interpretation question with an agency interpretation as well, I think that whether it's the district court or the circuit court, they're going to have a lot of questions for you about how does Loper-Bright apply, yes or no, or at least they should.
Kate, briefly, post Loper-Bright, courts can still employ some form of deference when considering agency interpretations of statutes. Can you remind us what Skidmore deference is and how it operates, and whether you think this will be a meaningful difference from Chevron in the immigration field?
Yeah, so Skidmore deference refers to when courts defer to administrative agency decisions as persuasive authority as opposed to controlling authority. And in determining whether to grant the Skidmore deference, they look at the thoroughness of the agency's decision, the agency's reasoning, its consistency with other decisions, and, overall, was the agency persuasive? As to your second question, will this be a meaningful difference from Chevron? Maybe, and sometimes. In my view, Skidmore allows for a more sort of results-driven analysis. If a court wants to affirm the Board of Immigration Appeals, Skidmore will be a helpful analytical framework to use to get there. And I think we saw this recently in the Lopez v. Garland case, which is a Ninth Circuit case in the Crim-Im context, where they said, okay, post Loper-Bright, we're not using a Chevron framework anymore. Let's crank this through the Skidmore framework. And in the end, ultimately deferred to the Board of Immigration Appeals. So while the analysis was different, you walked away kind of saying, wait, we got to the same place we might have gotten to under Chevron. And I think it took the wind out of the sails a bit of removal defense practitioners that were really hoping for circuit courts of appeals to do a more fresh analysis and less deferential analysis.
Thanks, Kate. There's so much more to say about Loper-Bright, but in the interest of time, we'll move on to the other case, not about immigration, but with immigration impacts, and I'll pass it to Ahilan.
Yes, I think I can do this a little bit quickly, just in the interest of time here. But the other one case that we wanted to discuss was Alliance for Hippocratic Medicine versus the FDA. I'm not sure I have the party right there, the other side, but it's a really interesting, very important case involving abortion. And the basic story is, the FDA approved mifepristone in 2000. It's a drug that induces abortion. Initially, the FDA required extensive safeguards for its use. Very early term, I think 7 weeks. You have to have 3 doctor visits. But then it relaxed some of those rules in 2016, and then more of them in 2019, because there's 20 years of data showing that this is a safe way of terminating a pregnancy. Then, after Dobbs overruled Roe, the combination of mifepristone and telemedicine, so doctors prescribing it, over video link, ameliorated a significant portion of the harm created by Dobbs, not all of it by any means, but 60% of all abortions happening in the US now use mifepristone. So a set of pro-life doctors formed a new organization composed of other doctors' associations. They incorporated themselves in Amarillo, Texas, which just happens to be the place where they can pick a single federal judge, this guy named Matthew Kaczmarek. And then they filed suit against the FDA's approval of the drug from 20 years ago, and also the later expansions of it. And they won. They won entirely in the district court, actually. Judge Kaczmarek literally banned the use of mifepristone. The Fifth Circuit sort of reversed the worst of that, but still enjoined the expansions and required that it be used only under the pre-existing more restrictive standards. And then the case went to the Supreme Court. You might be wondering, how do these people have standing to challenge? They're pro-life doctors. They don't prescribe mifepristone. They don't treat patients seeking abortion. And the answer was they don't. They lost 9-0. It was rejected for a mountain of reasons. I won't get into all of it. There's some really outlandish theories. The Fifth Circuit basically said they have aesthetic injury, like they said the injury that you have when you go to the beach and the beach gets polluted. That basically that like seeing pregnant like mothers and children being born is like that. But I don't want to get into all that. It's just it really is a sign of what a mess the Fifth Circuit has become as a whole for the law. But we're discussing it here because there are 2 standing arguments there that are similar to standing arguments that are routinely asserted in immigration cases. So one was that their organization, the Alliance for Hippocratic Medicine, expended resources opposing the use of mifepristone. And they said, look, we advocate against this and talk about its harms and all that, and that's a diversion of our resources. And of course, diversion of resources and also frustration of mission, which is sort of its cousin, are very common bases for standing that organizations have used in immigration cases. You think about Las Americas, I mentioned at the beginning, challenging SB4, that's an immigrants' rights organization, or the asylum rules, al otro lado, the TPS cases, the NAACP and Centro Presente. I mean, so much immigration litigation over the years has happened through organizations asserting that the federal policy that's being challenged is making it impossible for them to pursue their mission or requiring them to spend money in ways that they shouldn't have to spend to combat this illegal activity. Now, the Supreme Court rightly rejected the claim in this case for organizational standing because essentially this group had no pre-existing mission on which they were spending resources. It didn't provide any kind of other services. But the court also said that the underlying case that sort of created that line of doctrine, which is Havens Realty, established an unusual rule, which was unhelpful. And I think there are other passages in the case. We were talking about this in our email back and forth before this, which I think can be read to suggest even broader limits. I don't think that those are correct, but I think that people in court certainly could read them to suggest that this case is cutting back on that body of doctrine. The other part was that the doctors asserted that their own harms, these sort of crazy injuries I was talking about, aesthetic injuries and things like that, well, those they were asserting, this was an association that was suing, and it was an association of associations, and beneath that there were doctors. And so the association was asserting the injuries of the doctors. And that's also a very common basis, associational standing. Organizations can assert the rights of their members. The NAACP has done that for years. As have a bunch of immigrants' rights organizations at different points in time. The National Immigration Project, the National Lawyers Guild, I've represented many times. And there is a concurrence from Justice Thomas, which suggests that all of that is illegal and that there shouldn't be any associational standing ever. And that too would, I think, significantly undermine a lot of the ability of immigrants' rights organizations. If that, that's just one concurrence, only he joined it. But if that idea spread, which sometimes happens with his ideas, that could also be really problematic for people trying to challenge various immigration policies.
Something to keep an eye on. Karen, how does this decision fit together with other recent Supreme Court decisions, including the one from last year involving the DHS priorities memo, in terms of what it means for actors seeking to challenge policies they're not directly regulated by?
I mean, it's delightful for that. So this decision, right, which is 9-0, which is just kind of breathtaking in the unity for this court. But we had last term mainly 7-0. That was like a much more splintered decision, but there were 7-2 justices who said in the ICE priorities case, state of Texas, you have no standing. You're not regulated here. You are not a non-citizen who is either a priority or not a priority. You just don't like our immigration priorities. You don't like this immigration policy. You don't have standing, and the bar to establish standing when you're an unregulated party is higher. And no, we don't believe in parents patriae standing. And, it's been a major decision. It was directly useful in the case that Ahilan and I have together, where we intervened to defend the CHMB parole program and won that case on standing, really because of this ICE priorities decision memo. But here too, the court is saying, hey, doctors in the Hippocratic Association, you're not regulated here. You're neither a person who is pregnant, who might want to use mifepristone, nor are you prescribing it. And you were not required to prescribe it, and you're not required to perform emergency abortions, and you're just not regulated. So it isn't good enough that you have generalized moral and conscious objections, just like it's not good enough, state of Texas, that you have objections to Biden pro-immigrant policies. And so for me, that's the through line. Everything that Ahilan has said about, wait a minute, what is up with organizational standing? What is particularly up with the path that Justice Thomas is wanting very clearly to carve out and reverse? That is all well and true. But for me, the biggest thing is this is another enormous hammer that the Supreme Court has delivered to unregulated parties. And as a general rule, we don't have a hard time because our people are getting regulated, right? Our clients, whether they are organizational clients or directly impacted individuals, they're getting regulated by what we're challenging or seeking to protect. And so I don't think that this really harms us in terms of standing analysis, but yet is really a tool to kind of clear away the noise that is a policy dispute about immigration that plays out in the courts with unregulated parties.
And can you say really briefly, just mention two cases where both the sides of this issue are coming up in terms of interveners seeking to defend a program who have a stake in it and states who really don't have standing. The CHNV parole program and DACA. Talk really briefly about that if you can.
So CHNV parole program is, a really interesting example. And we were lucky to litigate that both with RACIS and the UCLA Center for Immigration Law and Policy before the judge who was reversed in the ICE priorities litigation case. I'm sure that mattered, you all. But there, again, Texas was like, oh yeah, we don't like this CHMV program, we're harmed. They couldn't show any harm, right? And we were able to use the ICE priorities memo with a judge who desperately wanted to hear from us. What does this mean? He wanted to hear from all the parties. What do I have to do for standing analysis now? And what do I have to do differently? And we were real clear with them. They've got to show harm. Texas has conceded that the number of CHNV nationals in the state has reduced since the program. We don't know what they're talking about, Your Honor. And ultimately, that's what won the day. Who knows how this judge would have ruled if we had gotten to the merits? We did not. Case is now briefed, and we're awaiting to see if there's an oral argument. DACA, very interesting. Who knows? Just a plug that your best case timeline and case information on the DACA case is going to be on MALDEF's website, so that's a great place to go. The DACA case is going to be heard the same day, the same time, the same courtroom as the parole in place KFT case. You can't even make this up, you all. October the 10th in New Orleans at 9:30 a.m. West Courtroom. What is up? It's also will be on the YouTube of the Fifth Circuit. But what's happening? Well, the case is up on its post final rule from the Biden administration. Is DACA lawful? Yes or no? But before you even get to jump, you know that MALDEF and New Jersey and the Department of Justice will be wielding this case and the ICE priorities memo case to say, excuse me, unregulated party Texas, you just don't like DACA and you're not harmed by it. So I expect that there will be a lot of standing discussion there too, that you'll hear these case names again. But remember, if you're digging in your memory banks for how did Texas establish standing in the DACA program, two reasons. One, they complained about the cost of issuing driver's licenses to DACA recipients, poor Texas. And CHMV litigation, to be clear, we put in our own expert challenging that argument. And we said, no, state of Texas, you make money. Here's all the ways you make money on your driver's licenses. They don't cost you money. Interestingly, Texas did not raise a driver's license argument in the Keeping Families Together case. But so are they having to spend more money than they make on the fee charging they do for driver's licenses for DACA recipients? That's question one. Here's question two. If DACA didn't exist, would some DACA recipients leave the state of Texas? In the underlying case, there is some discussion, and one of the experts said, yes, some of them would leave the state. Is that really true for these long-term residents of the state of Texas and DACA recipients? I think probably not. But this is what Texas is hanging its hat on to try to show harm as an unregulated party. And I do think that they're swimming much more upstream in light of these two standing decisions this term and last term.
Thanks, Karen. With our remaining time, we want to talk about a couple of the upcoming immigration cases for this term, and I'll pass it over to Ahilan.
Yes, so one of them I alluded to earlier is this case, Buarfa, which is another statutory jurisdiction case about the scope of 1252A2B2, which, broadly speaking, denies review over discretionary determinations but not necessarily all of them. And that's what Patel was about, and what these other cases I mentioned was about. This one is about whether a visa petitioner can get judicial review when an approved petition, in this case a marriage petition, is later revoked on the basis of non-discretionary criteria. So here you had an approved petition, and then later it's revoked because the agency says, oh, actually, the spouse here had previously engaged in a sham marriage. And everybody agrees that the sham marriage determination at the outset would have been reviewable, because that's a legal question, and one for which actually there's specific statutory review. But now the question is whether, if it comes through a revocation rather than at the initial stage, if that makes it reviewable. And I think it's partly about the scope of Patel, which I said there was a trio of cases, two have been sort of favorable and one unfavorable, the unfavorable one being Patel. And there's some dicta in that case, and there's about the force of that. That was a 5-4 case where Justice Barrett was in the majority, Justice Gorsuch was dissenting. The only other thing I'd say about it, there's a very interesting brief from Northwest Immigrants' Rights Project, and NILA, National Immigration Law Association, Litigation Association, arguing that 1252A2B does not apply at all outside of removal proceedings, because this is not a removal proceedings case. This is just a freestanding petition that's gotten denied. And this is a very powerful textual argument that they have in support of their view in that brief, because all of 1252 is about review of removal orders. And this, they're trying to apply it where this person hasn't been, there's no removal proceeding, a person doesn't have a removal order. So we'll see what happens. It's another one of these statutory jurisdiction cases.
Thanks, Kate.
Yeah, the next case that's going to be heard this term is Monsalvo Velasquez. And this case is about voluntary departure, which is the ability of a non-citizen to voluntarily agree to leave the country rather than being forcibly removed by the government. Under the immigration statute, when an immigration judge enters voluntary departure, the immigrant typically has up to 60 days to depart the country. However, if the non-citizen moves to reopen their removal proceedings, the filing of that motion cancels that voluntary departure order and some of the bad consequences that can come from violating the voluntary departure order. So the question presented in Velasquez is, what happens when the 60-day deadline to depart falls on a weekend or a federal holiday? Can the non-citizen be given until the following Monday or the day after the federal holiday to either depart or file a motion to reopen that would automatically terminate the voluntary departure order? And I will just say very quickly, I think this case matters. You might be thinking, wow, this doesn't seem like a big deal, a day or 2 or 3 after a weekend or a holiday. But, as immigration practitioners on this call know, the consequences for failing to depart in accordance with the voluntary departure order are severe. And so 24 hours actually really does matter. The citizen could be subject to monetary penalties and not be able to re-enter the country for 10 years if they don't comply with the voluntary departure order. Supreme Court will hear oral argument on this case on November 12th. So it's one of the first cases that will be heard in the term.
Michelle, I'm sorry to interrupt, but I'm embarrassed and I want to make sure to correct this. The great brief that I was just talking about was written by the Northwest Immigrants' Rights Project, the National Immigration Litigation Alliance, that's the name, and you all, the American Immigration Council. And I wanted to make sure to properly attribute that to superb brief in the prior case I was talking about before I fell.
Thanks, Ahilan. Do you want to say very quickly, if we have enough time, a couple of the pending cert petitions before the Supreme Court?
I mean, just one I wanted to flag, they're not currently pending, but they're right there. There's a circuit split currently on the question of whether people subject to prolonged confinement, imprisonment in immigration detention while their removal proceedings remain pending are entitled to bond hearings where they can seek release when they've been detained, sometimes for years. And now the Second Circuit and the Eighth Circuit have split on that question. And this is a question that I and many others litigated for a very long time. It was in the Supreme Court multiple times several years ago, and all the cases were resolved on statutory grounds. And now they're back. Sort of, they're not up there. There's not a cert petition yet, but I know the government, having lost in the Second Circuit in a case called Black, and it was considering that whether to seek cert, and the Eighth Circuit came out, in my view, the wrong way in this case called Banyi, and so both of those are potentially up for consideration.
Thanks. And Karen, the last potential one.
Yes, the last potential one is back to intervention. So this case, the short version is Chris Kobach, remember him? He's back, has sought to intervene super belatedly, as in up at the Ninth Circuit in the 2023 asylum ban rule, not to be confused with the current one, right? And only at the juncture that the parties, the federal government and the immigration side, were negotiating a possible settlement. And they were like, whoa, we don't like this one bit. We want to be up in here to make sure that you're fully keeping the asylum ban in place. But as we all know, 2023 asylum ban is pretty much replaced by current 2024 asylum ban. And so there's no question as to whether or not the federal government is still supporting and implementing its asylum ban. And the Ninth Circuit, I think correctly, rejected and denied intervention on behalf of Chris Kobach at this late stage. But he has sought cert and it is being opposed. And the reason I want to point it out is we are in this interesting mix. We talked earlier about Fifth Circuit intervention cases, right? CHNV, the Keeping Families Together case, where our side is seeking to intervene, but don't be fooled. The other side is often seeking to intervene as well. And this will be an interesting question. I think there's no doubt timeliness is a requirement for intervention as of right. It's extremely rare to get intervention up at the circuit. Certainly Texas the states knew they might care about this case way earlier than when they sought to intervene. So I think it was properly decided, but it'll be a very interesting litmus test as to whether the court even takes it at all.
Thanks, Karen. You brought us full circle. I'm sorry that we've run out of time, but I see similar themes in some of the questions, including whether we can provide a list of the cases we mentioned today. So we can do that afterwards via email when we send out the recording of this webinar. And otherwise, thank you all for joining us today. We really appreciated the discussion and your questions. And if you can consider a donation to the Justice Action Center for all their wonderful work, or the American Immigration Council, so that we can continue to provide webinars and other information like this. Thank you, Ahilan, Karen, and Kate, for all your incredible insight. And I hope everyone has a good day. For those of you in the Southeast, safe. Bye, y'all.